This meeting has been convened for the purpose of consideration by this committee of the Personal Injuries Assessment Board Amendment No. 2 Bill 2018, which was referred to the Select Committee by order of the Dáil on the 8th of November. I would like to welcome Minister Heather Humphreys and her officials to the meeting. Before we would begin, I would ask members to switch their phones to airplane safe or flight mode, depending on their device. It is not enough to just put them on silent mode, as this will maintain the level of interference from the committee rooms. Thank you. We will now proceed to the consideration of the bill. Does Section 1 stand part of the bill? Agreed?
Agreed.
Yeah. Does Section 2 stand part of the bill?
Agreed.
Does Section 3 stand part of the bill?
Agreed.
Does Section 4 stand part of the bill?
Agreed.
Does Section 5 stand part of the bill?
Agreed.
Does Section 6 stand part of the bill?
Agreed.
Does Section 7 stand part of the bill?
Agreed.
Section 8, Deputy Kelleher, do you have an amendment?
Yes, sure. I move amendment.
Okay,
on Section 8, yes, Minister, I suppose the purpose of this really, we've had these debates in Parliament for years, the difference between shall and may. And I suppose really what we're trying to get at here is to ensure that there's obligation for the judicial system to at least, be obliged to ensure that people who are non-cooperative with the system, that there would be some form of sanction. Now, I do accept that you have basically said that it would be interfering with the independent judiciary of the judiciary itself, and maybe I can accept that. Maybe with your clarity on the amendment itself, I might be able to accept it. But I'd like to hear firsthand why you can't, because I do believe that we are trying to send out a message here that people must be more cooperative with the system itself. It was set up for the purpose of ensuring that there will be a seamless, less adversarial, less costly system in place, and people, as I said, who do not contribute in a cooperative way to the system itself, when they are assessing damages or making their case, that there should be some sanction. And I suppose, Minister, we've made this point even in the context of today inside in the Parliament itself during Dáil questions, where there seems to be no sanction for people who genuinely are engaging in a process to scam and to fraudulently secure money by false means and presenting fraudulent evidence to courts, lying under oath, and just generally seeing the system to scam it. And any measure that I can, in my role as a spokesperson in this area, I will try and ensure we put forward measures that oblige the judiciary, oblige the prosecution services or the investigative services to be as difficult as they can on people who are non-cooperative or who are using the system in an abusive way to secure funds through fraudulent means and through the pretence of being injured. So that's the purpose of it, Minister, and if you can convince me otherwise, I'll revisit.
Okay, well,
Tara?
thank God, my God. Just to say, I do understand what you're trying to achieve, Deputy, but the effect of this amendment is to remove the discretion of the court as to what order the court may make in relation to what costs, if any, it will allow a claimant or respondent, taking into account the failure by the claimant or respondent to comply or submit in the manner specified in subsection 1. The amendment raises constitutional concerns in that it would cut across the constitutional principle of the separation of powers and the discretion of the courts to make an order for costs. Subsection 1 lists the circumstances under which the court can consider an adverse costs order, where the assessors have requested the claimant under section 23(1) to furnish additional information or documents in relation to his or her claim for special damages, and the claimant has not complied with the request. Where the assessors have requested the respondent or respondents under section 23(2) to furnish additional information or documents and the respondent or respondents has not complied with the request. Where the assessors have requested the claimant or respondents under section 23(4) to assist or cooperate with retained experts, and the claimant or respondents have not complied with that request, or D, where the assessor has requested the claimant to submit himself or herself to a medical examination arranged by PIAB, and the claimant has not submitted himself or herself to the medical examination. Section 8 provides that the court may order certain matters, taking into account the failure to comply or submit in the manner specified in subsection 1. The word may, which is referred to in this section of the bill, refers to the order a court may make on what costs, if any, it will allow a claimant or a respondent. The matter of the making of an order is and must remain a discretionary matter for the judge. The court must take the matters referred to in subsection 1 into account when deciding on whether or not to make an order. When the general scheme of the bill was published in June 2017, it was proposed under Head 7 that a court shall have regard to the failure to respond to a request for further information, documents or medical reports in determining the admissibility of evidence in subsequent proceedings, and that a court shall have regard to a failure to attend an independent medical examination in determining what medical evidence is admissible in the court case. The Personal Injuries Assessment Board Amendment No. 2 Bill 2018 was drafted in consultation with the Office of the Attorney-General. The Attorney-General was involved directly in relation to the wording of Section 8. It was decided that a proposal to limit a court's discretion as to the admissibility of evidence would raise constitutional issues, in that it would be cutting across the constitutional principle of the separation of powers. It is the function of the court and the constitutional duty of a judge to hear all the available evidence and arrive at a decision on foot of that evidence, and to determine issues of liability and quantum. A plaintiff also has a right to tender evidence before the courts. The court must retain discretion in any given case to ensure constitutional rights are vindicated and fair procedures are followed. This section of the bill, as drafted, by providing for potential financial consequences to be applied for non-compliance with requests by PIAB assessors, should have the desired effect to change behaviour and encourage parties to adhere to the requirements set out in the Act. For the reasons I have outlined, I would ask the Deputy, would he withdraw his amendment, because for those reasons I can't support it.
Deputy Kelleher, House Counsel, the amendment?
Yeah, well, I suppose, can I just come?
You can, of course.
Well, I suppose, from the point of view, Minister, even today inside in the Dáil, I asked the question about Minister Darcy's proposals to bring forward a constitutional referendum next year to cap awards. I suppose it gives an indication that this government isn't always very much in favour of the autonomy and independence of the judiciary. And what I'm trying to get at here is not to hamstring the judiciary into having to do something, but to ensure that they must take into account, at the very least, the non-cooperation by a claimant. And that really is the purpose of my amendment. Now, if you're telling me, Minister, that it is against the advice of the Attorney-General, and that it would be in breach of the separation of powers, of which I am a supporter of, by the way. Maybe Minister Darcy may not be, but I certainly am. That I will withdraw with an entitlement to reintroduce at report stage.
Noted.
Thank you, Deputy.
So the Section 8 Amendment 1 is withdrawn, but you may reintroduce at report stage.
Thank you very much.
Thank you, Deputy. Section 8 Amendment 2, Antara.
Sorry, yeah, I second that. Yeah. I move amendment number 2, and thank you. The purpose of this amendment is to delete subsection 8.2 and substitute a new subsection 2. So section 8 of the bill applies to applications made to PIAB on and after the enactment of this section, and to applications with PIAB on enactment of the section where the assessors have not requested information or documents from the claimant or respondent or respondents regarding special damages, or where the claimant or respondent or respondents have not been requested by the assessors to cooperate or assist with retained experts, or where the claimant has not been asked by the assessors to submit himself or herself for a medical examination arranged by PIAB. The amendment has been drafted by the Parliamentary Council in consultation with the Office of the AG. I am conscious that where the state sets up a system where people's rights are engaged, it is critical that the procedural and administrative system is clear and transparent. People need to know what they are required to do and what they are not required to do. The amendment to this section makes very clear as to the applications that will be covered by Section 8 on the commencement of the legislation. It is important that claimants fully cooperate with the PIAB process in order to maximise the model and ensure that as many claims as possible are settled in a timely and cost-effective manner. So what I'm trying to do is this bill will cover all the new claims and any claims that are in the system subject to the circumstances that I've just described. So we're just trying to capture as many as we can with the new legislation.
Thank you, Minister. Any comments there? Deputy Quinlivan? You're okay? Any further comments? Okay, so the question is that Section 8, Section 8, sorry, that the amendment be made. Agreed?
Yeah, agreed.
Yeah. And the question is that Section 8 as amended stand part of the bill. Agreed?
Agreed.
That Section 9 stand part of the bill.
Section 9. This is to do with the Book of Quantum, is it, Minister? Yeah. Again, Minister, originally it was meant to be 5 years from what I can remember in the first reading of the bill, and now we're down to 3 years, isn't it? It's a review every 3 years, the Book of Quantum.
3 years.
Yeah. And in the context of some discussions we had, either in Dáil questions or at some stage in the Dáil, we raised the issue around that there would be a comparison of other countries with a common law like ourselves in terms of assessing awards. And we were told at the time that we couldn't compare with other countries. And I just would like a little bit of an explanation as to why we can't compare awards and benchmark ourselves across what we would consider the norms. I mean, we do it in many other things, the price of medicines and in many other areas. We benchmark ourselves across OECD countries. I suppose in this context you'd want to be talking about common law jurisdictions in terms of awards. And the reason I say that, of course, is because our nearest neighbour, who we have a very similar legal system to, they make awards of around €4,000 for whiplash. And we're up at 20,000. Now, I don't know whose neck is thicker than the next, but I do know one thing for sure. We have a problem when it comes to awards vis-à-vis other countries. And I'm just wondering, what is the reasoning behind that? And if we are to review the Book of Quantum at least every 3 years, that there would be an explanatory as to how they arrived at that particular figure. Because it's fine just to publish the details as to what award should be for various injuries, but I think there has to be some broader assessment as to why they came to that figure, as opposed to just the arbitrary announcement that X should be paid out when a person is injured, when they have a certain personal injury. Because people simply can't get their head around it. And of course, the judiciary can't get their head around it either, because there is a large disparity across the various judicial jurisdictions in terms of awards, and maybe even down to individual judges. So the Book of Quantum will still be discretionary, but I think it has to have enough research and analysis done that gives it legitimacy, so that the judiciary can then act on it as well. And also that in publication of the Book of Quantum itself and the review every 3 years, that there would be some broader assessment than just the arbitrary figure thrown out as to what should be awarded in the context of injury. And the reason I say this, of course, is this is important beyond just this bill, Minister. because we are now talking about the Judicial Council Bill as well, which will in effect take its potential writing instructions, or discussions at least, from PIAB in terms of assessing awards. I'm led to believe that the PIAB will assist the Judicial Council in assessing what should be the broad benchmark. So if we have one benchmark which doesn't explain itself, then advising and helping if and when the Judicial Council is established, are we still not quite sure as to how they arrive at figures. So if I could have a small bit of clarity on Section 9 on that, Minister, I'd appreciate it.
Okay, so thanks, Deputy. Is that okay?
Yeah.
Well, just to clarify that, PIAB have actually offered assistance to the Minister or to help the Judicial Council, but they've only offered it. I don't know. That'll be up to the Minister when he's putting the legislation through, Minister Flanagan, whether he takes up that offer. I'm sure he will, yes. But they have offered to help.
Yes, well, it'll be up to Parliament, I suppose.
Yes, up to the Parliament. Right, okay. It'll be up to the Parliament to decide. And it'll probably be up to the Judicial Council as well, whether they decide or not. Actually, it'll probably be more when they'll have certain powers, and I'd imagine that they'll decide themselves when they have these powers, or whatever way it works out. Just to say that at the time of the publication of the bill, the second and final report of the Personal Injuries Commission had not been published. This report was subsequently published on the 18th of September 2018, and a key recommendation of the report is that the Judicial Council, when established, be requested by the Minister for Justice and Equality to compile guidelines for appropriate general damages for various types of personal injury. When the judicial guidelines are in place, it is intended that they will supersede the Book of Quantum. The intention for the future is that the Judicial Council will take ownership of the judicial guidelines for personal injury compensation, and that they will recalibrate them when they consider necessary. So that should be even a better situation, because they can change them quite easily.
Okay, thank you. So the question is that Section 9 stand part of the bill? Agreed? Thank you. That Section 10 stand part of the bill? Agreed?
Agreed.
That Section 11, Section 11 stand part of the bill. Deputy Quinlivan, would you like to speak here?
Yeah, it's my first amendment. I have two down today. Section 11 of the bill seeks to reconstitute the nomination process to the Board of PIAB. As it stands, 2 members of the Board are nominated by the Irish Congress of Trade Unions, ICTU, while one person is nominated by IBEC and 1 person by the Irish Insurance Federation, or any successor of it. The proposed change contained in Section 11 would remove the power of ICTU to nominate 2 people to the Board and replace it with 1 nomination from Insurance Ireland and 1 nomination from the Central Bank. The balance of the 2 nominations from ICTU and 1 from IBEC reflects injured parties and premium paying policyholders who should be the principal stakeholders in PIAB. I don't see the need for this composition of the board to change and in this way, and I think it would affect the balance on the board. Therefore, we are opposing Section 11 of the bill.
Sure.
Yeah, thank you. Section 11 amends the composition of the Board of PIAB in line with government policy to have more board members appointed through the Public Appointment Service. Section 11 removes ICTU and IBEC as bodies designated under the Act to nominate members to the board. As I mentioned at the second stage debate, it will be open to members of ICTU or IBEC to apply through the pass process when vacancies arise. Seeking expressions of interest for board appointments through the pass process allows for appointments to be made from a greater number of potential candidates with the desired skill sets, which can vary over time depending on the skills available to the board. Board members are appointed as individuals by the Minister, where in the Minister's opinion they have the expertise in a field of expertise relevant to the board's functions. The Code of Practice for the Governance of State Bodies, published in 2016, provides that board members should have the appropriate skills and knowledge appropriate to the activities of the state body to enable them to discharge their duties and responsibilities effectively. The Code of Practice also requires that in determining the criteria for board vacancies, the Minister consults with the chairperson of the board to identify the appropriate and collective mix of experience, knowledge and skills required to successfully oversee the performance of the board's function. All applicants who meet the criteria may apply to pass and be assessed. Corporate governance standards require that the board members act in good faith and in the best interest of the state body. The duty of the board member is owed to the agency and not to any specific stakeholder. Under the bill, it was proposed that 5 board positions will be filled through PASS, through open advertisement operated by PASS, who since 2014 have been responsible for putting in place an open, accessible, rigorous and transparent system to support ministers in making appointments to state boards. For the reason, I just wish to clarify for the Deputy that the current board consists of a chairperson, the chief executive of PIAB, and 9 ordinary members, of which 6 are nominated by external bodies designated under legislation. The Minister normally nominates a senior department official to the board. The external bodies are as follows: 2 persons nominated by ICTU, 1 person nominated by IBEC, 1 person nominated by Irish Insurance and Federation, 1 person nominated by the Central Bank, 1 person nominated by the Competition and Consumer Protection Commission. The bill proposes the 5 positions be filled through PASS, and I have to say, when the board was established, social partnership, it was a time at that stage when a social partnership was in place. And just to say that the Chair is committed regarding the skill set required for the board. So the Chair of the board is there looking at the skill set. So it's so really what I'm saying is the Chair, along with the 2 board members from PASS, they decide what skill set is needed, and for that reason they will have the flexibility to appoint or to recommend appointment from different skill sets. So it's for the reasons I have outlined, I would ask the Deputy to withdraw his opposition to Section 11.
I don't have I appreciate your response, but I don't think it's addressed the issue I have. What the issue is that IBEC are going to lose 2 seats on the board, and for that reason,
ICTU and IBEC as well.
And IBEC will lose 1 position as well, which I think
IBEC lose 1. We still have somebody from the
but I think you're making it more like more corporate Ireland going to be on the Insurance Ireland getting 1, and a nomination from the Central Bank as well, while you're taking off 2 from ICTU and 1 from IBEC. So that's the concern I would have. Look, if there's no support for this, I'll withdraw it, and with the proviso that we might.
Quinlivan, there's comments to be made. If you like, I'll leave you back in at the very end. Okay.
Just to follow up on it, just to say that it is open to them to apply through the PASS system.
Through the PASS system.
They can still do that.
Okay. Deputy Lawless.
Thanks, Chair. Yeah, I suppose I was trying to understand this amendment so that I could assess it, and then trying to understand Deputy Quinlivan's opposition to it so that I could take a balanced view in terms of what might be the right course of action on it. I think we have to be careful of being overly prescriptive on some of these boards. Sometimes we can get into the habit of saying there must be a representative from X sector and Y sector, and the voluntary sector and the business sector and the corporate sector and the regulatory sector, and before we know it, we've got 20 odd people on a board, and we're all going around saying how come these boards are so big, and somebody has to do something about them and make them smaller again. So I just think that maybe we can get a trapped in a kind of mindset that way. I'm not entirely sure. I'm not familiar with the initial or the original composition, but Deputy Quinlivan has said that ICTU and IBEC were on it, so almost sort of mark each other, and I can see to an extent why IBEC would be on it in terms of maybe, well, I suppose part of the reason that we're doing a lot of these reforms is trying to drive down the cost of business and to make insurance more affordable.
Clarification: ICTU can nominate 2 and IBEC can nominate 1.
Right. I'm not entirely clear, and I'm open to convincing on what specialist knowledge ICTU would bring to bear on personal injuries awards. I can see what perhaps the Patients Association or there might be other associations, and it's not obvious. I mean, trade union members are not the only people who slip and fall coming out of a shop, or maybe if there's a particular focus on employer injuries, but I don't think that's what's in PIAB. PIAB is far more wide-reaching. So it actually strikes me as a hangover from the days of partnership, and I think the Minister's mentioned that. And that was all the vogue, I think when PIAB was originally passed, it was 10, 15 years ago. And we had the social partners, as there was at the time, and every board going. It may no longer be appropriate, I suppose is the point I'm making. And I'm open to persuasion on it, but I'm not convinced that just doing what we always do because we always did it is the right way to do it. Maybe the board does need a different composition, but I'd say let's not make it too big, let's not be too prescriptive. And I think what the Minister seemed to be saying was that it's open to all parties and not to actually nominate, and if they pass the test and they get on the board, if they don't, they don't. It seems to be a lot of merit, I think, in that. So, as I said, I'm open to persuasion, but just trying to just trying to understand it a bit more, I suppose.
Minister, could I just get clarification? How many members are entitled to be on the committee through the pass system?
There's 11 in total on the board. There's one person nominated. At the minute, I was going to say that you would have 3 nominations. So one would be nominated by the Irish Insurance Federation, one nominated by the Central Bank, and one nominated by the Competition and Consumer Protection Commission, and a department official. The Minister normally appoints a department official to sit on the board. So that's 4, and that means there's 7 positions left.
And they will be
They will
appointed
go through
the
pass,
Okay.
and the chairperson would look at the skill set needed, and they would do that in conjunction with whoever sits on the pass board, and they'd look to see. But the point I suppose I want to make is that you know, the corporate governance standards require that board members act in good faith and in the best interests of the state body, and it's the duty of the board members is owed to the agency and not to any specific stakeholders.
Okay, thank you.
And that's what we were trying to achieve there.
Okay, any further comments there? Deputy Quinlivan, sorry if you want to come back in now.
Yeah,
there.
just it's not a case of we want to say just add our ICTU on to represent trade union members. That's not what we're about at all. It's just to make sure that there's been a lot of talk about fraud and people making false claims and stuff, and we all agree with that that's happening, and we want to deal with it. But also we have to remember that people do get injured, and they have to be compensated when they do get injured, and we want to make sure that there's a voice for them as well. So I think ICTU would be the voice for that. So that's why we have that amendment down. So, and I think it's important that.
Well, it's not an amendment; it's just an opposition to this.
Oh yeah.
Yeah. So there's not actually a wording there. You can always oppose it at report stage, can you?
Can I just come in, sorry Chair, just for one thing there, just to say that the assessors in any of these situations are independent from the board. The board is there to look and as an oversight for the agency, and to make sure that it's doing it's fulfilling its functions. And the Central Bank operate both a regulatory function and consumer protection function, and bring experience of both aspects to the corporate governance of the board, and that's why we have them on it. And the Competition and Consumer Protection Commission brings its financial management and information function to the corporate governance of the board, and also is consumer welfare knowledge. So I believe it's important then that we have both the Central Bank and the Competition Consumer Protection Commission, that they are designated, because they bring that experience and that aspect to it.
Thank you, Minister. Deputy, you can always look at this again at report stage.
Yeah, I'm happy to withdraw it if I can.
You will draw your opposition at this stage.
I may reintroduce it at report stage.
You may oppose.
Oppose it
at report stage. Okay. So Deputy Quinlivan is going to withdraw his opposition to Section 11, and the question then is that Section 11 stand part of the bill.
Agreed.
Thank you, and I would just like to, on the record, to note that Deputy Quinlivan may take leave to oppose Section 11 at report stage. Section 12, that Section 12 stand part of the bill.
Agreed.
Okay, Section 13 is opposed by Deputy Quinlivan. Deputy, would you like to speak on this, please?
Yeah, again, this is the second amendment. We're opposing this again in its entirety. This section seeks to give the Minister power to take the reserves of the PIAB board, which currently stand at around 19 million, as I understand it. I'm opposing this change, as these reserves have been built up by PIAB over years since its establishment, by continually re-engineering efficient processes and by fighting judicial reviews from vested interests. This money was collected for the purpose of assessing injury claims as provided for under legislation and for no other purposes. So perhaps it should go back to the policyholders who paid it in, either directly or through their insurance premiums. This has already been happening to an extent. For example, the fixed fee for an assessment has reduced from €1,500 in 2004 to €600 currently for respondents and their insurers. In addition, in 2011, the Exchequer has been repaid the €5 million loan for the setup costs. I understand that happened. PIAB has been very successful in being self-funding, and these reserves give PIAB a certain degree of independence. So therefore, I don't believe it would be beneficial for PIAB for these reserves to be taken. Therefore, we'll be opposing Section 11 as well.
Okay, thank you, Deputy Minister.
For those reasons.
Thank you, Kelleher. Section 13 inserts a new Section 74A into the 2003 Act. The Controller and Auditor General recommended to the Department and PIAB agree an appropriate level of revenue reserves to be retained by PIAB and the basis for holding such a reserve. The CNAG also recommended the introduction of an appropriate legislation to deal with excess funds held by PIAB. Legal advice obtained by the Department is to the effect that legislative change is required to enable the Board to remit excess monies to the Exchequer. The proposed amendment of Section 13 of the Bill implements the recommendation from the CNAG. It provides for a reserve policy for PIAB. It also provides that PIAB shall remit to the Minister, for the benefit of the Exchequer, any monies in excess of those authorised to be retained by the Minister, with the consent of the Minister for Public Expenditure and Reform. The Bill specifically provides that the Minister will have regard to the operational, capital and contingency costs of PIAB when determining the sum to be retained. In 2011, PIAB refunded its establishment costs of €6.9 million to the Exchequer. PIAB is independent in the exercise of its functions, and the Minister is not permitted in her executive function to interfere in any way with the day-to-day operations and functions of PIAB. Section 74 of the Personal Injuries Assessment Board Act 2003 provides a role for the Minister in relation to the provision of funds to PIAB. For the reason I have outlined that this section implements a recommendation of the CNAG, I ask the Deputy to withdraw his opposition to Section 13.
Deputy Kelleher.
Yeah, just very briefly, maybe for some clarity, and again, we might have to revisit this report stage, so I just want to put on the record that while I haven't tabled an amendment, just to get clarity initially. I suppose the concern, Minister, is while we have you here, we wouldn't have those concerns, obviously. But you could have a Minister that may not be supportive of PIAB, as you are. You may have a Minister for Public Expenditure who equally may not be supportive. And from my reading of the legislation, it would mean effectively that it would be up to the Minister, in discussions with the Minister for Business, Enterprise and Innovation, to decide what is appropriate funds for the running of the PIAB, both in terms of operation and capital costs. And I know that the CNAG has made a report, and we certainly don't want to have millions of euro of public funds not being used in a manner, and there should obviously be remittance to the Central Exchequer. But what I'd like to know is who actually evaluates the cost of running PIAB and ensuring that it can operate in a manner that we hope it will do. And I just say that in view of the fact that you could have a downturn and, you know, a cutback to public expenditure, and that there would be no real evaluation of the impact it may have on the operation and the capital investment required for PIAB to operate over a period of time. And I'm just wondering, is there any role for us to accept that there might be some form of independent evaluation of what is required on an annualised basis for the purpose of running PIAB, both in current and capital? And then beyond that, there would be a remittance to the Central Exchequer. Because sometimes I do fear, and again, today would be a simple example, and the report, or not the report, but the account, the report that was published in the Dáil today around the Office Director for Corporate Enforcement. I mean, we all know the reason that that didn't function is because it wasn't given enough resources. It was starved of resources. And we do need to have some independent evaluation as to what is required to run an entity, assuming always that the Minister for Finance and Public Expenditure at the end of the day is the one responsible for public funds, but that there would be an independent evaluation which would say, well, look, we need X amount to operate, and if you are taking beyond that, well, we can't guarantee the service. And that would be a reasonable assumption on my behalf. So, look, I equally just want to inform the committee that we may revisit this at report stage to see, can we do something to find some independent assessment as to how we come up with a cost that would ensure PIAB can function both in terms of operation for current expenditure and capital investment requirements from time to time.
Thank you, Deputy. Deputy Quinlivan, do you want to come back in?
Yeah, just again, I reserve my position that we may introduce it again, but I think the reason I want PIAB to maintain the extra money or the money that's left over is for things they can do. We're talking about changing the book account to them every 3 years to make sure that they're funded for that. As Deputy Kelleher said there, could be a different minister, not in your seat, but in the Minister for Finance, who decides not to give us the funding we need. Fees have come down already over the last number of years, and maybe they'll be able to do that again. So the reason I think is that PIAB should have the money and work more efficiently or whatever. So look, I'll withdraw the amendment, but with the proviso that we can reintroduce it again at report stage. Or the opposition, sorry.
Just maybe to give some clarification here, just to say that the bill here specifically provides that the Minister will have regard to the operational, the capital and the contingency costs of PIAB when determining the sum to be retained. And just to say that the Department and PIAB agree, that they must agree an appropriate level of revenue reserves, and the CNAG has recommended this. It's also a matter for the PIAB board the funding it needs, so it will establish what it needs, and then they obviously agree that with the Minister of the day, and the CNAG audit PIAB as well. So this is a recommendation that the CNAG has come up with. So that's why we're following through on it.
Okay, thank you, Minister.
Thank you.
Okay, so Section 13, Deputy Quinlivan has withdrawn his opposition, but both Deputy Quinlivan and Deputy Kelleher have flagged that they may revisit this at report stage. So the question I have to put is that Section 13 as is stand part of the bill.
Agreed.
Thank you. That Section 14 stand part of the bill.
Agreed.
That Section 15 stand part of the bill.
Agreed.
That this be the title to the bill, an Act to amend and extend the Personal Injuries Assessment Board Act 2003 and to provide for related matters. Is that agreed?
Agreed.
As the bill has now completed committee stage, it is recommended that members submit report stage amendments to the Bill's office without delay, as the report stage may be tabled at short notice. Where am I now? Okay, I have to. In accordance with Standing Order number 90, the following message will be sent to the Clerk of the Dáil. The Select Committee on Business, Enterprise and Innovation has completed its consideration of the Personal Injuries Assessment Board Amendment number 2, Bill 2 2018, and has made an amendment thereto. I would like to thank the Minister and her officials for attending today's meeting, and I declare the meeting adjourned until tomorrow, Wednesday the 5th of December at 2 p.m. Garva Maith, Good Minister.